This is a download from BFM 89.9, the business station.
This is Resource Center on Enterprise, and I'm Lim Soon Heng. As a majority of businesses in the country are SMEs, and many are in manufacturing, industrial relations is something quite central to human resource management. But maybe I'm not right in that it is only about the manufacturing industry. For that reason, I brought in Mr. Dharmen Sivalingam, the Executive Director of Meca Employers Consulting Agency. His company acts exclusively on behalf of employers to help them plan, navigate, and resolve HR issues related to industrial relations. What kinds of issues and disputes are settled within the context of industrial relations?
A very broad-based term, because industrial relations speaks of any relation issues, legal relations issues between employers and employees. When we use the term industrial relations, anything which affects terms and conditions of employment, the rights of an employee, what can an employer do and can't an employer do within legal boundaries, all of that will come under the term industrial relations.
You use the word legal. Is there such a thing as non-legal employer-employee relationship?
Let me explain. For example, for certain categories of employees, they may come within a particular legislation called the Employment Act 1955. Under that act, there are certain limitations as to what an employer can ask an employee to do. For example, an employee cannot be requested to work more than 12 hours in a day, and that is inclusive of overtime, except for very specific instances where you're talking of damage to machinery, something unforeseen. In a normal day-to-day business scenario, an employer cannot just tell an employee, listen, I've got a lot of orders, so I want you to work 15 hours today in order to satisfy my orders. That would not be allowed by law.
But the relationship between an employer and an employee are always governed by a legal document. Therefore, the relationship is a legal relationship.
You're right. Typically, that would be correct to say. But of course, we have got some employers who do not even have an employment contract for their employees. Now, there are some errant employers. What they do is to try to avoid the law. They have what they call casual agreements with the employees. So it's just word of mouth. They do that to try to avoid paying EPF maybe, to try to avoid creating a legal relationship.
So regardless of whether there is a legal relationship in the form of a contract or with or without a contract, the relationship is nonetheless a legal one, right?
You're right.
So in other words, if I am an employer, I really cannot get out of a legal relationship with my employee.
Strictly speaking, that's the correct answer.
Okay,
Yes.
So now we have this big picture. So what legislations do we have in Malaysia that govern this legal relationship between employer and employee?
Okay, great question, Suning. There are a fair few, in fact. Perhaps the more important ones, you have the Industrial Relations Act 1967, the Employment Act 1955, Trade Unions Act, and recently there have been a few new legislation, the Minimum Retirement Age Act, and then there was the minimum wage which has been brought in being recently.
Yeah, July 1st last year, yeah.
Yes, that's the Minimum Retirement Age Act. Then you have other acts which are related to the employee-employee relationship as well, the EPF Act, SOXO Act, so various types of act. And each of them provide for different aspects regulating the legal relationship between employer and employee.
To think about the relationship, you have to keep in mind all those various acts.
You're right.
Quite a task.
It certainly is.
So that's why we need to employ somebody legal to take care of such issues for us.
Correct. Well, I'll have to say that does puts a lot of issues on the table, and sometimes it can be overwhelming for employers.
Let's focus on the legal aspects of this relationship.
I think the major legislation that's very critical for these employers to understand is the Employment Act 1955. What this act provides, there's a little bit of biasness, and let me explain. The act doesn't apply to everyone, SH. It only applies to some categories of employees. I think the focus should be on two particular categories. The first category is for employees whose wages do not exceed 2,000 ringgit per month. They come within the scope of the Employment Act. And the second category is even if the wages are more than 2,000 ringgit per month, but if the employee is predominantly engaged in manual labor, he still gets covered by the Act.
Let me clarify. So, for instance, in an office like ours, we might have some people getting paid more than 2,000, some people about 2,000 or less. So those below 2,000, they are covered by the Act. Those who are paid more than 2,000 are not covered by the Act.
Absolutely
So
correct.
in other words, we can work in the same place, but we might not be covered by the Act.
You're right.
Okay.
For the employees who are covered by the Act, you have to provide terms and conditions which are no less favorable compared to what is found in the Act. So let me give you an example. You must give those employees, those covered under the Act, at least 11 public holidays in a year. So assuming you have an ignorant employer and an ignorant employee, and the employer says, okay, listen, I'm paying you 1,500 ringgit and I'm going to give you 4 public holidays in a year. And the employee doesn't know his or her rights,
Right.
they sign
She
off.
accepts it.
But this is illegal because they come under the scope of the Employment Act. You cannot give them terms which are less than 11 public holidays in a year. To follow on from what you mentioned, let's say the staff working next to this particular staff is someone whose salary is 3,000 ringgit, who's not a manual laborer. For him, if he accepted the 4 public holidays in a year, those are his terms and conditions.
How interesting.
Yeah.
Okay. You're talking about over whom the Act covers. Yeah?
That's right.
Okay, beyond that, what should employers know so that they don't fall into this issue?
The Employment Act talks about terms and conditions. The other major big ticket item would be the Industrial Relations Act. Now that act applies to all employees, regardless of salary, regardless of designation and job nature. And under that act, and herein lies a fallacy amongst employers. You see, in all our contracts, we have a clause which says either party may terminate the contract by giving notice or paying salary in lieu of notice. And because it uses the words either party, seeming to suggest it applies to both employer and employee, employers think that if I have an employee who is not performing even for no reason I don't like him, I can just
Give a month's
give a
notice.
month's notice and off you go. And that's actually not correct because that employee can file a complaint under the Industrial Relations Act for unlawful dismissal.
So what does this mean then? If an employer wants to terminate an employee, like you say, it works in favor of the employee can submit a letter of resignation, give the kind of notice that's required by the contract, and then goes, right?
That's right.
But the employer can't.
You're right. The employer can't do that let me say that another way. If the employer does that, and if the employee challenges the dismissal within 60 days with the Industrial Relations Department, the employer is potentially going to end up losing his case and paying a lot of money in compensation to the employee. To answer your question, can or can't, I suppose it's a yes or no answer in the sense that if the employee doesn't know of his legal rights, so he gets a letter from the employer saying, okay, here's 1 month's notice as per your contract, your last day of employment will be 1 month from today. The employee thinks that's perfectly allowed because that's what's in the contract. And so he does not file his complaint within 60 days, employer gets away with it. But if the employee knows of their rights and they file a complaint, the employer could end up being in trouble.
What happens if the employer gives a rolling contract on an annual basis? In other words, you are treated as a contract employee for only 1 year.
Very controversial area. In fact, some employers have deployed that method to try and circumvent the law because a fixed term contract which expires upon the expiry of the term, termination can take place automatically. However, if you keep renewing that contract repeatedly, then there is this notion of, is that really a genuine fixed term contract? Or is this a clever employer trying to get round the law by keeping someone on a rolling contract? And there are case law on this point. The point that's important here is the contract a genuine fixed term contract? And the law basically states that if the job is a job which is permanent in nature, using the fixed term contract is not actually good conscience, and therefore the court is most likely to state that, or rather come to a conclusion that this is actually a permanent contract disguised as a fixed term contract. So the employer will get caught. However, if it's a genuine fixed term contract, then that's fine.
What does that mean if it's genuine and yet it's rolling?
Right.
Of course, the burden of proof shifts onto the employer to
You're
show
right.
that. Yeah?
And let me be a bit more illustrative.
Hold that thought. Dharmen Sivalingam of Meca Employers Consulting Agency. We're talking about industrial relations and its place in HR management. The assumption that any agreement between a willing employer and a willing employee is a good and legal contract isn't necessarily true. There are laws to ensure minimum requirements. Coming up, When is a rolling fixed-term contract an indication of full-time employment? And what happens if a willing employee wants overtime? Are there prohibitions? This is Resource Center on Enterprise, BFM 89.9, the business station.
Be firmly motivated. BFM 89.9.
You're listening to Resource Center on Enterprise, and I'm Lim Soon Heng, speaking with Dharmen Sivalingam of Meca Employers Consulting Agency. Often the assumption is that so long as both parties are willing to enter into a contract of employment and both are agreeable to the terms and conditions of the employment, all is acceptable, legal and binding. Not so. Dharmen, you are about to launch into an example of a genuine rolling fixed-term contract.
Yeah, let's say I'm a construction company and I have received a contract with a particular developer to put up a 20-story building, and my projections show that I will need X number of workers for 2 years to complete the project. Now, in that instance, and let's say at the end of the 2 years, I've not completed the project, so I need to extend my contract, my employee's contract. That would be a genuine contract. But there is a case in point, involved a school and its teachers, and the school put all its teachers on fixed-term contracts, and they kept renewing it and renewing it and renewing it. And it came to a point when suddenly the school said, well, you know what, I'm not going to renew your contracts. Off you go. The teachers took this matter up to court, and when it went to court, the court said, okay, hang on a minute. This is a school. A school can never run without teachers. So the job of a teacher in a school setup is a permanent job. So what's the purpose of putting you on a rolling contract? That would be an example of a non-genuine fixed-term contract.
Why do companies like the school have that kind of a contract?
There are two answers to that. The first, some employees are not aware of what we just spoke about. They feel that, contracting parties are free to enter into any sort of contract. So they think, well, so if I want it rolling, so be it. But perhaps the more sort of accurate answer would be, some employers feel if I have a rolling contract, and if at the end of the term of that contract, if I don't want the employee, I can just say, guess what, contract expired, off you go, and my risk of being sued in court is a lot less. So it's a method which is sometimes being used to circumvent the law.
And this has nothing to do with how much the person is being paid, right? So whether you're under 2,000 or above 2,000, this is still covered by the Act.
That's right. In fact, if I can add...
And this is the Industrial Act, right?
Industrial Relations Act. In fact, if I can add a little bit more, and this is a hugely controversial area, the Minimum Retirement Age Act, which came into force 1st of July, has a provision within it which states any fixed-term contract which is for a duration that is longer than 24 months, including renewals, that employee is entitled to stay with the company until 60 years, which is the retirement age. So, if I would explain a little bit more, if a fixed-term contract, let's say for a term of 2 years, 24 months, and it comes to an end, then the Minimum Retirement Age Act does not apply because it's maximum of 24 months. But let us say if I enter into a fixed-term contract with an employee for 36 months, and upon the expiry, I tell my employee, okay, thank you very much, 36 months are up, off you go. Now, the Minimum Retirement Age Act states if it's for more than 24 months, you have to keep that employee in employment until 60 years. A view that's being taken by many is that the Minimum Retirement Age Act now has sounded the death knell to any fixed-term contracts for more than 24 months. And
which means that people won't go into that kind of contract.
That's the idea of Parliament. In fact, I've spoken in detail to the guy who drafted that particular provision. That was indeed his intention.
With regard to SMEs, though, what areas are particularly challenging for them?
I think a lot of SMEs, I don't blame them. They don't have an awareness of the laws. And typically SMEs, the focus in the first few years is all about the business. So it's all about getting as much money in and keeping my costs as low as possible. And there is a false notion that as long as I have an agreement with my employee, I can do as I please. To give you an example, for an employee who comes under the scope of the Employment Act, let's say I've got a factory, I've got 25 staff on a factory line, and I've got a sudden surge in orders. In order to satisfy these orders, I need my guys to work long hours of overtime. So I tell them, listen guys, just do 10 hours of overtime every day or 7 hours of overtime every day, and I'll pay you for it. Now that's not allowed by the law.
Even though the people are willing to work.
Yes, in fact, indeed, in most instances, the people are excited to work because that gives them extra pay. But the law stipulates that you can't have employees work more than 104 hours of overtime in a month. Now, employers, they feel that my employee is happy doing it. So, it's a win-win situation. What's wrong with this? Now, the problem is if the Labour Department or the Jabatan Tenaga Kerja comes to know of this, you can be fined for up to 10,000 ringgit for each instance of non-compliance.
And each instance means each person also?
Yes, that could be the view that they can take. Each person, so you have times X number of employees times X number of months. That can be a crippling amount to pay as a fine.
Why is this provision there, even though when you have two parties of legal age, therefore are able to enter into a contract of mutual benefit?
If I were to just look back at the figures, you see, when they say 104 hours, where did they come up with that figure? The Employment Act presumes that workers will work 6 days in a week. And the law says, the Employment Act says normal hours of work, this is excluding overtime,
8 hours.
is 8 hours. So you've got an extra 4 hours you can do in a day. 4 hours times 26 days in a month gives you 104 hours. So the law is trying to inbuild some sort of work-life balance. So there's a sort of idea in their mind that getting a guy to work 12 hours a day, 6 days a week, that's as much as you can get him to work. I see a lot of sense in that because more often than not, you're talking about blue-collared workers who are on their feet. They've got machinery to work with, tools, heavy tools to carry. It can be quite taxing to ask them to work beyond 12 hours a day.
The question of safety also
comes
even,
into the picture.
And the compromise there is that it might not endanger the individual himself or herself, but it could endanger the other staff.
Absolutely right.
What other issues should SMEs keep in mind?
Okay. Now, you see, this is where an understanding of the Employment Act can take the SMEs a long way. Let's go back to that situation of a surge in orders. If you have a good understanding of the Employment Act, you can actually keep your costs down within legal boundaries. For example, the law states 8 hours a day is the maximum you have for your normal hours of work. Now, there are some exceptions to that, but I don't want to go into too much of detail on that. But the law does not stipulate that your hours of work must start from 9 and end at 5, which is why you have got shift companies with shift. So you can have typically a 3-shift system. Each shift is for 8 hours long. That suddenly means you have got 24 hours of operation without paying a cent in overtime. Because Mr. A comes in for the morning shift. When he leaves, Mr. B comes in for the afternoon shift. When he leaves, Mr. C comes in for the night shift. Each guy works 8 hours, no overtime. That's a provision which is allowed. Now, what about rest day? The law says you must give 1 rest day in a week. But the law does not force the employer to say the rest day must be Sunday.
Or Saturday.
It's just one day.
Yeah.
So I can have pockets of employees who have different rest days, which then literally means I could have a 24-hour, 7 days a week operation without having to pay any overtime, without having to pay extra pay for rest day work. Sometimes we fall into this notion of, everyone must have a Sunday off. And then what happens is if I do that and I ask an employee to come into work on a Sunday, my cost really shoots up because rest day rate is pretty high. But that does not have to be the case. You see, I could have one guy working on a Sunday, one guy off day on Monday. You can
stagger them.
That's right.
In other words, you don't have to break any of the laws if you understand the laws and know how to appropriately disseminate your employees to work in different areas.
Absolutely, it's totally allowed for by the law. It's just about knowing the rules and working within the confines of the rules.
Seems to me that employers on the whole, especially among SMEs, they are not aware of the legislations involved. But at the same time, I can quite understand when you have so many pieces of legislations.
You're quite right. I think putting this burden on employers is sometimes can be seen as unfair. And when the Ministry of HR comes up with these changes, they need to take efforts to try and cascade this information through various means. But, there's always going to be slips between the cracks. I think the starting point is when someone starts a business, the focus rightly should be on the business, but then there must be some, you must be open enough to understand I need to reach out either to talk to experts or find out from the labor departments what they can and they can't do. So you can't overlook that.
Who provides these kinds of information? I know as an employer, the responsibility really falls on you to go buy the legislations to read or engage a lawyer or HR people. Are there institutions, are there organizations that provide this kind of information as part of especially among young entrepreneurs, this kind of information?
I do believe that the Jabatan Tenaga Kerja or the Labour Department, anyone can reach out to them and ask them questions, get some booklets, leaflets. And also, I believe that there is under the Ministry of Human Resources, set up a Human Resource Development Fund who have now come up with a sort of an academy specifically for SMEs to reach out. So that's another avenue that's available. And of course, there are numerous training providers who provide training on these areas. You'll have to, of course, employees will have to pay to attend for it.
Sure.
But that's, I think, would be, off the top of my head, that would be the kind of sources that they can reach out to.
Dharmen Sivalingam, Executive Director of Meca, Employers Consulting Agency. This is Resource Center on Enterprise, and I'm Lim Soon Heng, BFM 89.9, the business station.
Thank you for listening to this podcast. To find more great interviews, go to bfm.my or find us on iTunes. BFM 89.9, the business station.